I'll make my first introduction, which is Mr. Frank Swain. He's a partner in the Washington, D.C. office law firm of Baker and Daniels. During the Reagan administration, Mr. Swain served as the Chief Counsel for Advocacy. Mr. Swain, I appreciate you being here, and I look forward to hearing your testimony.
Thank you very much, Mr. Chairman, and it's a pleasure to be here in front of you and Mrs. Velasquez and the other members of the committee. I must say that I was greatly cheered when I came in the room about 12:45, and there was a line out the door for a hearing on regulatory flexibility, acquiring an importance that I had forgotten that it had in the public eye. But it's really important that you're holding this hearing. It's really important that you're considering these two bills. I had the opportunity to participate when I worked for the NFIB years and years ago in the original congressional discussions about regulatory flexibility in 1980. I want to emphasize some of the points that were made by Mrs. Velasquez, because in 1980, the Senate and the House were both controlled by the Democrats. This was a bill that was passed with strong support from both sides of the aisle, strong support from the chairman of the Senate Administrative Law Subcommittee, then Senator John Culver from Iowa. But it was a bit of a walk into the unknown. There was really only one other bill that was slightly like it, and that was the National Environmental Policy Act, which had been passed in 1970. That law said, when we make rules, when we take actions as a government, we have to think about what the impact of those actions is on the environment. So this was really the first time that they tried to take that principle of regulatory review and twist it to a different focus. And that focus is, when we make rules for all sorts of important reasons, safety of the food system, protection of the environment, whatever, we have to take a look at the impact of those rules on small business. And I think this is the real virtue of the regulatory flexibility, and we have to go further. We have to think about whether there are other ways of getting to the same regulatory goal, more flexible ways, besides the one-size-fits-all approach, which is typically the starting approach for most agencies. Again, as the opening statement suggested, the problem with regulation is a particular problem for small business because small business doesn't have the broad economic or employee base to spread the relatively fixed costs of regulation. So it's important to attempt to tailor the regulation to small business. My statement mostly addresses issues relating to the regulatory flexibility analysis, which is what was the state of the law when I served as Chief Counsel. I don't have personally as much experience with the panel review process, and so I'll defer to others on the panel that are more experienced with that. But it's really important to note that we do achieve a balance between a better regulatory flexibility act that is less easily avoided by agencies and the very real dynamics of getting regulatory decisions made in some sort of prompt and efficient way. That is becoming an issue, particularly an issue involving science and technology, drug and medical device development. And so we do have to maintain a balance, but I think that if we can swing the balance of the current law more towards tightening up some of the ambiguities that were inevitable 30 years ago when we were sort of guessing at what might work, that will make a real difference as far as small business is concerned. I detailed in my statement 5 or 6 specific issues. This is a complex subject, and I'd be happy to take questions or submit comments on any other specific issues that the committee may want my perspective on. But the need for these reforms after 3 decades of experience with the regulatory flexibility is very plain. Small businesses continue to be, under any economic assessment, the job creator, and we have to do our best as a society and as a government to eliminate or lessen to the extent possible the fixed cost of regulation, which is such a serious drag on that job creation process. I'd be asked that my statement be received in the record, and I'd be happy to submit any further comments or respond to questions. Thank you very much.
Thank you, Mr. Swain.